Welcome back to another deep dive. We're here to, cut through the noise and get you the key insights fast. Today, imagine you're caught up in the justice system as a victim. You'd need that initial police report, the FIR, right, to know what's happening. Sounds simple, but we're looking at how India's brand new criminal justice law, the Bharatiya Nagarik Suraksha Sanhita, 2023, let's just call it the BNSS, might actually, very paradoxically, complicate this for victims. Our sources, we've got the official legal text, Supreme Court judgments, parliamentary reports, the works. Our mission today is really to unpack this seemingly tiny change in wording, just a couple of letters, but with potentially huge implications for getting justice. Okay, let's get into it.
Absolutely. And it's fascinating, isn't it, how one small legal detail can ripple outwards and affect, well, real people in really significant ways. The core question we're digging into is, does this new BNSS really live up to its promise of being citizen-centric,
Right.
especially when you look closely at this right to get a copy of the FIR?
Right, the stated goal versus the practical reality.
Exactly. Sometimes they don't quite align.
So let's zoom right in. The specific change. Under the old system, the Criminal Procedure Code, getting a copy of the FIR forthwith, like right away, free of cost. That was only for the person reporting the crime, the informant.
Correct. Only the informant was explicitly mentioned for that immediate free copy.
But now, the BNSS in Section 173, subsection 2. What does it say?
It says a copy should be given forthwith, free of cost, to the informant or the victim.
Ah, that word, or. Just two letters,
Yeah.
but that's where the complexity starts, isn't it?
It really is because, and this is crucial, the law has always been clear. The person who files the report, the informant, doesn't have to be the actual victim.
Okay, explain that a bit more.
Well, think about it. Anyone with knowledge of a serious crime, what they call a cognizable offense, can file an FIR. It could be a neighbor, a witness, anyone. The victim might be someone else entirely, perhaps unable or unaware at that moment. So the informant and the victim can be two different people.
Got it. So the BNSS adds the victim, which sounds good, aims to be more inclusive, more citizen-centric, as you said. But using or, does that mean if the police give it to the informant, they've fulfilled the requirement? They don't also have to give it to the victim.
That's precisely the ambiguity. It opens up that possibility. It's not a guaranteed and. And, the Parliamentary Standing Committee actually spotted this. They were reviewing the bill.
Oh, interesting. What did they say?
They specifically recommended changing the wording to informant and the victim. Or, alternatively, or both, as the case may be, just to make it crystal clear that both should get it.
To remove that ambiguity. So the concern was flagged even before the law was passed.
Yes. It highlights that tension between the stated aim empowering victims and the actual legal text, which might fall short in practice.
Okay, so that's the or problem.
Yeah.
But you mentioned there was another layer to this, something about the word forthwith.
Right, forthwith. It sounds immediate, doesn't it? Like without delay.
Yeah, you'd think it means you get it quickly, which is vital for a victim trying to follow their case.
You would think. And the section uses the word shall be given forthwith. Normally, in law, shall implies something as mandatory, a must-do.
But there's always a but, isn't there?
But the courts, including the Supreme Court, have interpreted this specific provision, even under the old law, which has similar wording regarding the informant. They've held that providing the FIR copy is directory, not mandatory.
Directory versus mandatory. Okay, what's the real-world difference? Why does that matter so much?
Well, think of directory as like a guideline, a strong suggestion. Police should do it. But if they don't, it might not automatically invalidate the whole investigation or lead to strict penalties for the officer. It's less enforceable, you could say.
Not a strict command, then.
Exactly. Whereas mandatory means it must be done. Failure to comply has clearer, often stricter consequences. So calling it directory weakens that guarantee of access, even with the word shall.
Wow. Okay, so let's try and bring this all together. What's the bottom line for a victim under this new BNSS? It seems like the law tried to be more victim-focused by explicitly adding victim to who gets the FIR copy.
Yes, that was the clear intention.
But the specific wording, informant or victim, combined with this long-standing judicial interpretation that giving the copy is only directory, it feels like it might actually make it harder for a victim to be absolutely sure they'll get that crucial document, especially if they weren't the one who initially reported the crime.
That's the potential paradox, yes. It raises a really significant question, I think. We know victims now have established rights to participate throughout the criminal process, investigation, trial, even appeals. But how can they effectively exercise those rights? How can they meaningfully participate right from the very beginning if they can't even be guaranteed access to the foundational document, the FIR? Shouldn't that access be mandatory for participation to be real?
That really puts it into perspective. It forces you to think about how these interpretations, these specific word choices in law, actually shape what justice looks like on the ground for individuals. What does this specific situation tell us, maybe, about the broader evolution of victims' rights and legal reform? It's definitely something to mull over. Thank you for joining us for this deep dive. Keep digging into these complex but absolutely vital topics.